Thank you. My name is Joe Gerlach. I represent the Métis Nation of British Columbia, a group whose traditional rights are guaranteed by Section 35 of the Charter, and who has provincial-wide presence in the province of British Columbia. The Métis Nation, unfortunately, has not been part of and have been excluded from any consultation process with respect to the sockeye or any other fishery in the province of British Columbia. DFO, although excluding the Métis Nation from representation in British Columbia and from the the consultation process. Okay, the consultation process in British Columbia has provided the Métis people in other provinces and in other regions an opportunity to be heard and an opportunity to be consulted in relation to various resource-based issues. In spite of having a foot in both the First Nations camp and the European camp, the Métis Nation has, as I said, been excluded from any meaningful consultation or any consultation, absolutely. So that has been one of the central themes, or the central theme, of the MNBC, or the Métis Nation submissions in their written submissions to this commission. We seek an opportunity to be meaningfully consulted with respect to the sockeye fishery and any fishery for the benefit of the Métis citizens and people in British Columbia, and for the preservation and sustainability of that resource. The Métis claims a right to be consulted based on the principles advanced in the Haida decision, where it's stated there's a duty to consult with Aboriginal groups who have advanced the prima facie right to be consulted. That consultation is not based on the proof of right, as it may arise through court decision, but based on the duty arises when the Crown, and I'm quoting from Haida, Crown acknowledges, when Crown has knowledge real or constructive of the potential existence of the Aboriginal right or title and contemplates conduct that might adversely affect it. As a Section 35 Aboriginal group, Métis say, and partially as our participation in this commission, the Métis say they have a potential Aboriginal right, and there are some actions with respect to the sockeye fishery that will affect that right. In relation to the establishment of the right, the Métis further proposed that there are submissions and evidence in the commission hearings that referred to an expression or a signal that perhaps there could be a time when Aboriginal rights could be determined without having to present evidence and arguments through litigation, a process that the Métis has not gone through yet. And therefore, that evidence was provided by Ms. McGivney with respect to the rights issue, and it leads to believe that there is a light in the litigation tunnel. And I'd like to just quote from some of Ms. McGivney's testimony, and that was found or stated in the September 2011 transcripts hearings, and I'm looking at pages 14 and 15. On page 14, Ms. McGivney answers some of the questions posed by Mr. Eidsvik about what the policy is with respect to DFO and how they do it. And he quoted Alaska and New Zealand, and he asked on line 29, can you tell me why, I mean even Canadian, why are Canadian fishermen in the public fishery in the Maritimes being treated with more respect than the BC commercial fishermen have been shown in those in the public fishery? And Ms. McGivney responds, yes, in BC, one of the challenges we have is that Aboriginal rights, the extent and scope of those rights, haven't been defined. And so the department has developed policies to approach how to address some of these interests that have been brought forward, and that actually then the policy and then it becomes indiscernible. On page 15, starting at line 9, Mr. Eidsvik asks, I'm in agreement with that. So you're saying that there's Aboriginal fishing rights in the Fraser River that have not been defined. I'm trying to summarize what you're saying. And Ms. McGivney responds by saying, I'm saying in BC there was a The department has taken a broad policy approach because of the fact there have not been long-standing treaties, and the Aboriginal rights are not. The scope and extent of those are not clarified. So the policy approach is that there is a policy approach to try to provide, through our programs, provide access for food, social, ceremonial purposes. And we've also looked to providing First Nations with some economic opportunities on the same basis as the regular fisheries. This carries on that day with some evidence as well from Ms. McGivney responding to Ms. DeForest. And on page 25 of that transcript, there was some discussion about similar issues. Ms. DeForest asked Ms. McGivney, you'd agree with me that this negotiation process is evident. It's not evidence-based. Is that correct? And Ms. McGivney responds, the treaty process. And Ms. DeForest asks, that's correct, the BC treaty process. Ms. McGivney responds by saying, yes, that's right. And that as a result, there's no Crown inquiry to research into the validity of the territorial assertion or the geographic scope of or the nature of any Aboriginal rights. For example, fishing of the First Nations in question. Is that correct? And Ms. McGivney says, I don't know, sorry, can you say that again? Ms. DeForest says there's no Crown inquiry into the validity of the territorial assertion that's brought in with a statement of intent, and Ms. McGivney says there's no requirement for that. There may be some Crown investigation on that, I don't know. To be fair, further on in the testimony, Ms. DeForest reads in this regard, it should be remembered that DFO does not have a mandate to determine whether an Aboriginal group has Aboriginal or treaty rights to fish, or the nature and any scope of those rights. And Ms. McGivney responds correct. I read that in for the purpose of saying, ultimately, it's the view of the Métis Nation that enforcement or the provision or the determination of rights, which now rests with the courts in consideration of Indian and Northern Affairs Canada policy, DFO policy, is contrary to the notion of consensus, the notion of consultation, reaching consensus with all interested parties in the sockeye and fishery and the Fraser River generally. I suggest that although it's not a current acknowledged method of obtaining recognized enforceable rights, which is left with the courts, it is an expression of hope that sooner or later the need for Aboriginal rights to be determined through an adversarial court process may give way to an understanding by way of negotiated rights with appropriate evidentiary safeguards. If DFO is not the authority in that regard, certainly it can ignite the process with Indian Northern Affairs Canada. Leaving aside our earlier discussion about the duty of DFO to consult with the Métis Nation, it is contended that consultation with the Métis would provide real benefit to the sockeye fishery in the Fraser in relation to fish monitoring and enforcement of DFO policy. We note that in the commissions and the committees and the reports leading up to the wild salmon policy, that the majority of the reports spoke about effective and timely monitoring, which was a serious issue that had to be dealt with in more detail. And we have dealt with this in more detail on our written submissions. It appears that without a significant increase in the number of DFO agencies and officials in the field, effective and dependable fish monitoring must rely on the data provided by resource users. Without the numbers provided by the Métis, that data is incomplete. Mr. Jantz gave evidence on that subject on May 11th. And I just briefly read a bit of what he had to say. In response to Ms. Chan, Mr. Jantz said, who asked Mr. Jantz and Mr. Parslow, just to wrap up with the Fraser River's First Nations FSC and Economic Opportunities Fishery Catch Monitoring, could you speak to whether or not you feel the catch monitoring and reporting report provides you with accurate and reliable estimates? And if you'd like to add to that, any recommendations that you have for improving the process? Mr. Jantz says, responded similarly to what Mr. Parslow stated, but further added, there are opportunities for improving some of the catch estimates in the section of the Fraser River immediately above what we call the mid-river area. So it's the upper Fraser. In that particular area, we don't have full coverage of the fishery, and our current funding levels through AFS programs primarily in many years often do not cover the full duration of the fishery. So we're put in a position where we have to extrapolate catch for those periods when you don't have coverage. So that's one area where we could certainly improve our monitoring. And it's our submission that the Métis, with province-wide representation, representing something like 35 communities throughout the province, would benefit, a consultation with the Métis would benefit the monitoring circumstance that is the gap in monitoring that's been evidenced by Mr. Jantz. In addition, besides monitoring, the studies refer to a need to effectively deal with enforcement of DFO policies. If the Métis were part of the consultation process, they would certainly assist through monitoring and presence throughout the province, assist in the enforcement of current DFO policies. Mr. Parslow responded to in a similar fashion to Mr. Jantz with respect to that issue. And if I can read what, from the September 11th transcript, what Mr. Parslow had to say about that. In response to Ms. Chan's question, talks about the drift net fishery, but in one sentence says on line 27, I mean, the other piece that would be providing some sort of independent validation of catch numbers, I think those are the main things. The other piece would actually rebuilding the relationships with groups we're not receiving numbers from and addressing those concerns so our data set is more complete because there's a hole in our data set at that time. The MNBC, the Métis Nation, sees a need for peace on the water. While consultation is central to the issue of maintaining a relationship between all users and determining in advance allocations of a sockeye resource, the current manner that DFO proceeds in allocating the resource by not including all stakeholders, MNB, the Métis Nation included, is in the consultation process prior to allocation has a detrimental effect to that relationship. The ultimate resulting allocation may not be affected, but if all stakeholders have a voice, at least gaining an understanding of the perspectives of all parties would be helpful. I'd like to speak very briefly about the culminative effect of the philosophy surrounding the disappearance of the sockeye and the Fraser, and I've had some readings in with respect to the tragedy of the commons, and I'm not sure if that issue has been brought up, but that's a philosophy that deals with the issues relating to the depletion of a common resource, and specifically relating to the costs of overpopulation in relation to the use of a common resource, with the inevitable and ultimate result, the exhaustion of that resource. While that philosophy may or may not be applicable in this instance, it seems that it at least has some relevance. The proposed remedy provided by that philosopher, Mr. Garrett Hardin, to that inevitable result and the preservation of the common resource was the requirement for a change in society's values. Society's currently, and I think that value is reflected in DFO policies, it's reflected in the manner in which DFO proceeds to allocate resources, is currently based on the commercial value of the sockeye fishery. It's based on, and it sees that as a society-driven response. What I think, and what the MNBC thinks requires to be done, is a change in the social values that lead to this depletion, that may save this resource. And the change should come from society in general, so that there is no reliance on the commercial value, total reliance on the commercial value of the resource, but instead a value in the intrinsic value in having a unique species like the sockeye preserved for the uniqueness itself. Certainly there's food, social, and ceremonial as far as First Nations are concerned. There's food, the necessity for food, But that, in our view, takes and it's stated in DFO policy, it takes second place behind the conservation of this resource. The conservation of this resource is dependent upon, in our view, a change in social consideration of the sockeye and other fishery in the Fraser. All of the stakeholders who have an interest in the sockeye fishery can work together for a common purpose. A common purpose being the preservation, the conservation of, and the sustainability of this resource. Meaningful consultation with all of the stakeholders, including the Métis, and engagement of society as a whole. And that poses certainly a problem to engage society as a whole when stakeholders claim absolute rights, claim prior rights, which we recognize are certainly a valid point. But in order to engage society as a whole, I think it's necessary to ensure that society has an interest, a definable interest in the resource. And until that happens, society will have difficulty becoming fully engaged in this process, and the common tragedy may occur, which is the depletion and the extinction of this resource. It's not our suggestion to paint a gloomy picture, but in following certain philosophical threads, it seems to me that there's an inevitable result here that should be, that we need to deal with, and only through society's engagement, in our view, will that happen. I bow to the philosophy of the First Nations, who clearly seek they seek the right to manage resource, bow to their traditional ecological knowledge, the use of that knowledge in order to proceed, and this is a management issue, and I think use and consultation with all the parties would certainly be a benefit for that purpose. I do want to point out that the use of traditional knowledge on the behalf of DFO, the science on behalf of DFO has, to the exclusion of traditional knowledge, does not accommodate the role that traditional knowledge can play in the preservation and sustainability of the resource. Captain Dukeman, on behalf of the Métis Nation, has commented on that subject, and I do point out that there's a large discipline surrounding the principle of integrated science. At the end, and the Métis Nation believes that expanding the use of traditional knowledge would be advantage to the fishery. Department of Fisheries and Oceans to focus fully on implementing the wild salmon policy. Clearly, there is an issue around surrounding the funding for the wild salmon policy, and there's been some delay in implementing it. As a result of the delays, the Métis Nation has a reserved confidence in the final implementation and effectiveness of the wild salmon policy. However, it is a program, it is a policy, it's in existence, and that's why the Métis Nation has a reserved confidence in it. In our view then, Mr. Commissioner, we see, as I said earlier, a need for peace in the water, consultation process which includes all interested parties and which involves society as a whole. And I think, I know it's early, but those would be our submissions. And we have provided submissions which cover our view of the need to be consulted, and in particular the Métis who have been excluded and who have, in our view, a right to be consulted. And we would ask Mr. Commissioner that there be some indication that DFO consider at least, at the very least, some consultation process.
Thank you very much, Mr. Chair. Thank you. I understand, Commission Council, that we're now adjourned until tomorrow morning. Thank you very much.
The hearing is now adjourned until tomorrow at 10 a.m.